G'day everybody and welcome back. This is podcast number 2 for LS 13010, Evidence and Proof. I'm still Anthony Marinac, and today we're going to be looking at the two paramount rules of evidence law, relevance and admissibility. These really are the fundamental concepts behind evidence law, and if you don't understand these fundamental concepts, the rest of the course is going to be almost impossibly difficult. So this is probably the most well, I won't say the most important material that we'll cover in the week, but it is information that you really need to understand for the rest of the semester to make any sense. So if you get to the end of this lecture and you get to the end of the reading and you still haven't got your head around relevance and admissibility, it would be a great idea to jump onto the bulletin boards and say so, or to get in contact with me directly, because these are the key concepts that underpin the entire course. So by the end of the lecture and by the end of the readings, you should be able to explain the meaning of relevance and how it's applied. You should be able to describe the forms of evidence which need not satisfy the relevance test, describe how the admissibility rules apply as an exclusionary test, talk about judicial discretion to exclude evidence, and talk about the concept and meaning of what we call a voir dire. So let's go through those one by one, starting with the relevance rule. The relevance rule is the central rule of all evidence law. It says that evidence that is relevant should be received and weighed by the courts unless some special rule demands that it should be excluded. So what is relevant? What makes evidence relevant and what would make evidence irrelevant? The definition comes to us from the case Re van Beelen, which is a South Australian case from the 1970s. And the definition is that evidence is relevant where, alone or in conjunction with other facts, and having regard to the common course of events, it tends to prove a fact in issue. So there are 4 elements there. The first is that evidence can be relevant alone or in conjunction with other facts. So some evidence is not going to immediately appear to be relevant because you have to combine it with other facts in order for the relevance of the evidence to become clear. Second, having regard to the common course of events. This is a fairly peculiar way of saying the court is allowed to apply common sense. So the court is allowed to apply some general common sense to the way that it interprets things that are brought forward in evidence. The third element is that to be relevant, evidence must tend to prove. We'll talk a bit more about this in just a moment, but tends to prove is really quite a low bar. We could be saying must prove conclusively, but the definition doesn't say that. It says that evidence is relevant if it tends to prove. The final element is a fact in issue. So a fact in issue is something that is a source of contention between the parties. Not all facts are going to be an issue. A great example is a sexual assault case. Now imagine that you're defending a person who's been accused of sexual assault, accused of rape. Their argument is that the sex was consensual. Now we all know from criminal law that the crime of rape is the sexual penetration of a person without consent. In this case, both sides agree that there was sexual penetration. What they don't agree on is whether there was consent. So in this case, sexual penetration is not a fact in issue. It's not something that the parties are arguing about. So evidence that simply goes to show that the accused had sex with the alleged victim is not going to be relevant because it doesn't prove a fact in issue. So if we look at those 2 slides, what they're telling us is that anything that alone or in conjunction with other facts and having regard to the common course of events tends to prove a fact in issue should be placed before the court, received and weighed, unless some special rule demands that it should be excluded. What you'll find out in a few minutes' time is that those special rules are the admissibility rules of evidence. So our starting point is that everything relevant should be open to be considered by the court, and the other side of that is that nothing irrelevant should be considered by the court. And that's important. It's important that the court makes sure that it's not considering irrelevant facts. The most obvious of those is discrimination. Let's say that a court decided that blonde-haired witnesses were unreliable. And so the very first question that was asked of any witness is, what is your natural hair colour? That, of course, would mean the court was considering irrelevant material, because there's absolutely no reason to believe that a witness is more reliable or less reliable as a result of their hair colour. The only things that the court is allowed to consider are matters that are actually relevant. Now that's the definition under the common law in Queensland, but as we mentioned last week, the Uniform Evidence Act applies in the Commonwealth jurisdiction and in the jurisdiction of a number of other states. The Uniform Evidence Act provides a specific definition of relevance, and it's actually kind of cool, and it's not terribly different from the common law. So I've put a slide in here which lists the definition so that you can use it not only to learn the Uniform Act definition, but also to better understand the definition in Queensland. The heart of the definition is in section 57. It says that evidence is relevant if it could rationally affect, directly or indirectly, the assessment of the probability of the existence of a fact in issue in the proceeding. So in other words, if the probability that a certain fact is true can be affected by using rational thought after considering the evidence, then that evidence is going to be relevant. That's pretty much the same thing that the common law is saying, only I think that they've expressed it a little bit more carefully and a little bit more effectively in the Uniform Evidence Act. So how high is the bar? In order to be relevant, how relevant does a piece of evidence need to be? How persuasive does it need to be? How much does it need to be able to logically affect the probability that a fact is true? Well, the answer is not very. You see, poor evidence, evidence that's not particularly compelling, is still evidence. It's just not particularly good evidence. So relevance is not the same as probative value. Relevance tells us whether the material should be considered by the court at all. Probative value tells us how important it's going to be in the court's reasoning process. The two are quite different. In order to be relevant, all that evidence needs to be able to do is slightly move the balance in favour or against the probability that a certain fact is true. It's not a high bar to meet. Now you'll remember that one of those aspects of the Van Beelen definition was that evidence can be relevant if it's considered alone or in conjunction with other evidence. Evidence that's not immediately focused on a fact in issue we refer to as indirect or circumstantial. Circumstantial evidence does not directly show that a fact in issue is more or less likely to be true. Circumstantial evidence combines with other evidence to make it clear that a certain fact is or is not true. HML and the Queen is a good case to exhibit this. In HML and the Queen, they were discussing the reactions of a victim of child abuse. The victim in question really hadn't reacted terribly badly to being molested by her stepfather. She really hadn't reacted terribly much at all. She'd had a chat to him and gone to sleep after the offence was committed against her. Now, ordinarily, the court would be quite justified in saying, well, can we believe this person's story because they really haven't reacted in the way that we would expect someone to react if they'd just been the victim of a sexual crime? In order to explain that reaction, the prosecution introduced evidence to show that in fact she had been systematically molested over a period of years by this perpetrator, so that in fact the conduct for which the perpetrator had been charged was just the latest in what had become a routine process of abusing this victim. Seen in that light, the victim's response to this particular incident becomes much more comprehensible, and the court therefore becomes much more likely to believe the victim's account of events. So you can see that the evidence that the perpetrator had previously been abusing this victim was not directly relevant to the question of whether the perpetrator did so on this particular occasion, but it was relevant when combined with the other facts that were brought forward about this particular occasion to explain why the victim's reaction was such as it was. That's really quite a useful little example, and it's a case worth having a look at. So we've talked about direct evidence, which directly has an effect on the likelihood that a certain fact is true. We've now also talked about indirect or circumstantial evidence. The third type of evidence we want to talk about is prescribed evidence. Prescribed evidence is different because relevance is not considered. And the reason relevance is not considered is that the Parliament has already considered it. The Parliament has already said this particular form of proof is going to be regarded as proof of this particular fact because we, the Parliament, say so. Best to understand this by an example, and the one that I've given in the PowerPoint slide is the Transport Operations Road Use Management Act, which is basically the road rules in Queensland. There's a provision in there, section 124, relating to the proof of ownership of a motor vehicle. And basically what it says is, if a motor vehicle is registered in a person's name, the law is going to presume that that person owns the motor vehicle. Now that of course is not always the case, and so it's possible to bring other evidence to show that that presumption shouldn't be made. But by and large, if the police, for instance, want to prove that a particular motor vehicle that's, say, been used to courier drugs is owned by a particular person, they're not actually going to have to show any title documents relating to the car. All they're going to have to show is that the car is registered to that person, and the court will then take that as evidence that shows that that car is owned by that person. So you can see the question of relevance never comes into it. The only question that matters is, has the prosecution brought the type of evidence that the statute prescribes to prove that particular type of fact? You'll find that prescribed evidence comes up more and more in modern legislation. The parliaments are starting to really get the hang of using prescribed evidence to say not just what the law is, but also how particular aspects of the law should be proven. The second type of fact that you don't need to bring evidence forward for is called a presumption. This is a situation where the law will presume that a certain fact is true, even when it's not. The best example that I can come up with comes out of the Succession Act, and it's what we call the presumption as to survivorship. You see, sometimes if two people, particularly two people are in a relationship, both die, it will matter who dies first. Now let's say you've got a husband and a wife travelling in a motor vehicle. The motor vehicle is involved in a collision, and within a matter of 30 seconds after that collision, both of them have died. Logic says that it's quite unlikely that they died exactly simultaneously. it is much more likely that their deaths were separated, and they might have been separated by seconds, they might have been separated by minutes, but by the time emergency services arrive, both of them are well and truly dead. There is going to be no way to tell with any amount of certainty which of those two people died first. So the law applies a presumption. We call it the presumption as to survivorship, and the presumption is that the older person died first. The law doesn't actually care whether the older person died first or not. What the law needs is a way to resolve the problem so that we can get on with working out who owns the house. The way that the law resolves that problem is to apply a presumption. Now, presumptions are usually rebuttable. So if you can actually bring evidence to show that one of the two people in the car crash was observed by first aiders to still have a pulse at a later time than the other one, the court might take that into account in order to rebut the presumption. But when there's no evidence at all, the court will simply presume that the facts lie in a particular way. The third type of evidence that we need to talk about where there's no question of relevance is called judicial notice. And look, I really do apologise for the photo that I've included in the PowerPoint here. It's ridiculous, but I just couldn't go past it when I saw this photo. The idea of judicial notice is that some facts are so notorious that they just need not be proven. An example is Wednesday follows Tuesday. You don't need to prove to the court that Wednesday comes after Tuesday. We know that Wednesday comes after Tuesday. The case there, Nye and Niblet, is an old English case. In this particular case, there was an English statute that imposed criminal penalties upon anyone who committed an act of cruelty towards a domestic pet. And domestic pets in this context were differentiated from, for instance, stock on farms, and they were differentiated from wild animals. So these were particular offences of cruelty committed against domestic pets. In this specific case, 3 young boys were convicted of committing acts of cruelty resulting in the death of a house cat. But it was alleged on their behalf, in their defence, that the prosecution had not demonstrated that this particular cat was being kept as a domestic pet, and that therefore the elements of the crime hadn't been made out, and therefore the defendants were entitled to an acquittal. The court said, no way. The court said that the concept that cats are kept as domestic pets is so notorious, so well known, that there's actually no need to bring any evidence that that's the case. Now, judicial notice is a weird thing because it does tend to change over time. For instance, the notion that cats are kept as domestic pets, there are areas in central Queensland, areas in western Queensland, where feral cats are a massive problem, and that feral cats are actually hunted because of the damage that they do to the ecology of those parts of Queensland. In those areas, of course, the concept that cats are automatically regarded as domestic pets would be laughable. There are other facts that were once matters of judicial notice that are now no longer matters of judicial notice. For instance, in the 1940s or 1950s, you would not have to have proven that 2 people in a de facto relationship were a man and a woman, because the court would have automatically presumed heterosexuality in relation to everybody. These days, of course, there's no judicial notice of the fact that, or the concept that, any relationship between adults involves a man and a woman. It's just not something that the court is regarding anymore as indisputable, because these days, of course, it's very much disputable. And so judicial notice does tend to change over time as social circumstances change. But if something is so notorious that it's indisputable, then you probably won't need to bring any evidence. So where are we at so far? We've talked about relevance. We've said that something is relevant if Alone or in combination with other facts, it tends to prove a fact in issue. We've said that the court should take account of anything that's relevant and that it mustn't take account of anything irrelevant. We've said that evidence can be relevant either directly or indirectly, in which case we refer to it as circumstantial evidence. And we've pointed to three types of fact that don't need evidence at all. And those are prescribed evidence, presumptions, and judicial notice. If you remember the definition that we started with Van Beelen right back at the start of this podcast, we said that the court should receive and weigh relevant evidence unless there is a specific rule to the contrary. And I mentioned at the start that those specific rules to the contrary are the rules of admissibility. The rules of admissibility say that there is some relevant information that should not be considered by the court. So the rules of admissibility are exclusionary. Their job is not to rule types of evidence in, their job is to rule types of evidence out. So the presumption is that anything relevant is admissible unless an admissibility rule comes in and knocks the evidence out. Okay, so it's an exclusionary set of rules. Evidence tends to be excluded for one of three basic reasons. Now there are a lot more than three rules, but all of the different admissibility rules can really be tucked under three headings. The first one is because evidence is inherently unreliable. So there may be some evidence that is relevant, but it's so inherently unreliable that we're really wasting our time by bringing it in front of the court. Admissibility rules will prevent that evidence from being considered. Second is because the evidence would be likely to mislead rather than inform. You will find that much of the time this semester we will talk about the balance between the probative and prejudicial values of particular evidence. A good example here is evidence of somebody's criminal past. Evidence of somebody's criminal past might well have some passing relevance to the likelihood that they've committed the crime that they're accused of now, but it's actually much more likely to be prejudicial than probative, because it will make a jury or a judge think, well, they've done crime in the past, they've probably done it again. And in fact, there's no logic in that. There's no logic that says that somebody who's committed a crime in the past is necessarily going to have committed a crime in the present. The third rationale is where public policy demands that evidence be excluded. The two biggest examples of this are where there's a public interest in having certain evidence kept quiet. So for instance, at the time that I'm recording this podcast, Australia is still well and truly ensconced in battle in Afghanistan. If certain evidence was going to result in danger to personnel on the battlefield, then there would be very good reasons for not putting that evidence in front of the court. The other type of public policy that results in evidence being excluded is where evidence has been obtained unlawfully. Okay, if evidence that was obtained unlawfully was allowed in front of the court anyway, it would almost be encouraging people to go out and commit unlawful acts in order to gather evidence. So the court says, because we don't want to encourage this sort of unlawful behaviour, we're not going to receive any evidence that is gathered unlawfully. So that's a public policy decision that's made by the court. What you will find is that the next 5 or 6 topics will take those 3 rationales for exclusion and we'll go through them in much more detail. At this point, for this lecture, all you really need to retain is first the notion that admissibility takes some relevant evidence and knocks it out. Second, that it's an exclusionary process, that it rules things out, not in. And third, that we have these 3 rationales for exclusion: inherently unreliable, more likely to mislead than inform, and public policy. Those aren't the only ways that evidence can get excluded. In criminal cases in particular, Judges have what we refer to as a judicial discretion, or a discretionary power to exclude evidence. This discretionary power flows from a judge's basic duty to run a fair trial. So if evidence is put before a judge and the judge believes that the evidence ought not properly to be considered because it is going to result in injustice, the judge has a discretion to rule that evidence out. Let's have a look at this in some more detail. The first discretion is unfair prejudice. Evidence is prejudicial if it might lead the jury to form unfair views about the accused person's guilt. And we've just discussed that example where an accused person has been convicted of crimes in the past. So what's meant to happen is that the judge will consider the probative and the prejudicial value of the evidence. I want to introduce you at this point to a case called Pfennig, which we'll come back to several times during the course of this course. Pfennig was a case in South Australia where Pfennig was suspected of having abducted, raped and murdered a 10-year-old boy. There wasn't enough evidence for Pfennig to be charged. 12 months later, in a place only about 15 kilometres from the scene of the first offence, Pfennig abducted a 13-year-old boy, raped him, and then the boy escaped and made his way to police. Pfennig was subsequently arrested and he confessed to the second of those crimes. Police looked at the similarities between the two crimes and said, "We have evidence to show that Pfennig was in the location where the first boy disappeared. We now have evidence to show that Pfennig has committed certain types of crime that we are pretty sure were committed upon the first victim. We think we're now in the position where this evidence means that we can charge this person and take them before the court." Difficult decision to make now. Does the fact that this offender committed a certain offence 12 months later actually tell us anything about the likelihood that they committed the earlier offence? Should the judge have admitted this information, or should the judge have said, "No, this is prejudicial, I'm going to rule it out"? In this case, the judge said, "This is not prejudicial. This information is actually strongly probative," and the judge ruled it in, and Pfennig was convicted. Now we're going to look at this case again several times on the way through, and it will be interesting for you to apply your critical thinking to this case and see whether you agree with the judge's decision. For the record, I do, and I think that as we look more closely at this case through the semester, the correctness of the judge's thinking becomes more apparent. But just because I say that doesn't mean anything. I'd like you to apply your own critical thinking skills to that particular case. The next type of judicial discretion relates to unfair evidence. Unfair evidence is evidence which, in all the circumstances, if you used it, it would be unfair to the accused. So this is a good example might be evidence that was obtained by the use of trickery. Now, evidence that was obtained by the use of trickery, by tricking the person into giving the evidence, might well be absolutely accurate evidence. But there's still something that's just not quite cricket about using the evidence against the person. And so if the judge decides that it would be so unfair to use the evidence against the person, the judge can exclude it. The final discretion is evidence that was obtained unlawfully. Imagine for a moment a world in which police still officially needed warrants in order to search people's houses, but they knew that even if they went into a house without obtaining a warrant, the information that they obtained was still going to be able to be put before the court. What would there be to stop police from committing break and entries constantly in order to obtain important evidence in relation to serious cases? The answer is pretty much nothing. The courts see it as important to maintain the integrity of the justice system to require that evidence that's put before the court must be obtained lawfully. Bunning and Cross is a great example. This is a case where a motorist was pulled over for driving erratically, and the police officer pulled this motorist out of the car, took one look at him and said, "You're drunk, mate." Took him off to the equivalent back in the day of what we would now call a booze bus, and applied the second level of testing, the more accurate level of testing, to determine this driver's level of blood alcohol. And the driver, of course, came up with an unlawful amount of blood alcohol. What they argued in court, however, was that the statutory requirements for blood testing at that time required that the initial screening test be administered on the side of the road. So in other words, the rules required that the driver would have to blow in the bag on the side of the road, and if that test showed that they were under the influence of alcohol, then they should be taken away for a more accurate test. So the argument was made that in this case, the second test was unlawful because the driver never had the opportunity to provide a roadside breath sample. Now, I get the sense when I read the case that the High Court wasn't particularly happy with letting this driver off, that the High Court would rather have convicted this driver for drunk driving. But at the end of the day, the High Court said it's important that police follow their own procedures. It's important that where there are procedures set up by the Parliament saying to police, this is how you must gather evidence, well, the police ought not to set that parliamentary decision to one side. If there's a process there, police ought to use it. If they don't use it, and the evidence is obtained unlawfully, the court's not going to receive it. So those are the three basic judicial discretions. They only apply in criminal cases. Please don't give me an assignment or an experiential essay or an exam question where you apply those judicial discretions in civil cases, because it will hurt me as much as it hurts you when I have to give you a very poor grade for answering that question. These are criminal cases only. Let's move on from judicial discretion. The next point that I want to make is that in law as it's practiced in modern Australia, a lot of the rules of admissibility could be said to be under attack, because there's now a large and growing number of pieces of legislation that actually exempt the authorities from the use of the full rules of evidence. For instance, if you're arguing a child-related matter in the Family Court of Australia, the full rules of evidence do not apply. If you're in the Administrative Appeals Tribunal, or the Queensland equivalent, which is the Queensland Civil and Administrative Tribunal, the full rules of evidence do not apply. In most military law cases under the Defence Force Discipline Act, the full rules of evidence do not apply. So whilst we're looking here in this course at the rules of evidence as they apply to the general run of criminal and civil cases, you do need always to refer to the legislation that governs the substantive area of law that you're arguing under, and make sure that these rules of evidence do actually apply. However, generally speaking, the fundamentals that we've just talked about in the last half hour of relevance and admissibility are going to underpin absolutely every other aspect of evidence that we talk about for the next 9 weeks. Finally, this week I want to talk about a beast called the voir dire. A voir dire is like a trial within a trial. In a voir dire, the only question is whether certain evidence is going to be admissible. So, in the voir dire, the prosecution and the defence, or the plaintiff and the defendant, will argue about whether a certain piece of evidence should be admitted to be heard as part of the main case, or whether it shouldn't be admitted to be heard as part of the main case. Most of the time, particularly in criminal cases, a voir dire will be conducted without the jury being there. And this is important because if certain information is going to be brought up by the prosecution and the defence wants to argue that that information should not be entered into evidence at all, it's a bit late to make that argument if the jury's sitting there listening during the voir dire, because the jury's already heard the evidence that the defence didn't want them to hear. So the voir dire is often conducted in the absence of a jury, and where possible, voir dires are actually conducted before the jury is even empanelled. In a civil matter, the voir dires might be conducted before the main arguments even begin. If you think about it, that's really sensible, because it means by the time the actual case gets underway, by the time the main arguments are being brought forward, both sides know which of their evidence they're going to be able to rely upon. Because if they have some contentious evidence that they're trying to bring forward, the judge has already decided, already looked at it and said, yes, that evidence is going to be admissible. Now, of course, that doesn't mean the judge is going to find that evidence compelling. It doesn't mean that the judge is going to give them hints about who's likely to win. It does, however, mean that they can confidently bring the evidence forward as part of a broader case. So what standard of proof should apply in a voir dire? If the voir dire is a criminal case, should the criminal standard of proof apply? If the voir dire is a civil case, should the civil standard of proof apply? Or, given that but we've already said in this lecture the bar is quite low because all the evidence needs to do is have a rational capacity to affect a fact in issue, should the standard of proof in a voir dire reflect that very low bar? Believe it or not, the rules about the standard of proof required in a voir dire are actually really complicated. They're far too complicated for us to go into in any real depth in a 40